Hey everyone, Harry here to talk about the day by day vigil as we watch the Supreme Court and try to determine what it will do and when it will do it in the immunity case. So recall, they have a motion for a stay, which is styled an emergency motion, a please, whatever else you do, just put on the brakes on what's going on below. And if the Supreme Court doesn't put on the brakes, the car chugs along back to Judge Chutkin's. No, I really didn't mean that wordplay. To recommence the proceedings that were interrupted when Trump bought his immunity appeal. All right, but for emergency applications like this, death penalty is a very typical one. But a special one because so often there'll be a writ of execution expiring at midnight and they have to really decide within a few hours. It can go either. They can either consider it at their conference when they go through all the different kinds of cases methodically and in regular order, let's take that as option one. There was a conference last Friday. They typically announce the decisions or what they've done at the conference the following Monday. This week they didn't because the following Monday was a holiday and they did it this morning. And what was not on the list? The immunity case. Just a little asterisk to what I just said sometimes, and you don't know why, they are the Supreme Court. I mean, you do know why. It's often if it's a really important case on the day of the conference, the afternoon. So if we were just thinking about the conference, the next one is coming up this Friday. And if they took up the stay application in regular order, then they'd go through 5 votes. There would be a stay, and fewer than 5, there wouldn't be. And then there's the question of whether they would construe it as a motion for review, that is certiorari, and both stay the case and agree to review it on almost certainly an expedited basis. Okay, so that's the common track. But for emergency applications like this, they don't have to take that track. They can basically just be, they're 9 separate little law firms and papers circulate and each justice votes, and that justice's votes get all passed around. And if you get to 5, the stay is there. And if you get to the last justice and no 5, the stay isn't. Now, they might at that point construe the what's, with 4 votes, what's left is a motion for cert, but that wouldn't matter. Notice it would be academic at that point. I mean, it wouldn't be academic. They would take up the question, and in the very off chance they ruled for Trump, everything would be bedlam. But if they take up the question, but they don't grant a stay and they don't rule for Trump, then things have just returned to Judge Chutkin and they remain there undisturbed. So it's just now now that Tuesday has come, the Tuesday morning, normally would have been Monday morning with the holiday, and there has not been an announcement. We actually have to be ready kind of at any time that they would move through one at a time the papers, let everybody know individually their votes. These things go around. I did these at the court in death penalty cases where, it could be really gut-wrenching, whether or not a 4th vote to review. And then, of course, you need the 5th vote for a stay. Otherwise, the prisoner is executed and the case is mooted out. All right, one other big factor affecting timing. They could already have gone through all 9, and they could have decided to not grant the stay, and there could be one or more justices who want to dissent from that ruling. And so when it's published, the motion is denied. Justice Alito files the following statement in which Justice Thomas joins, and they get some time. They can't polish it and wait weeks. And if it comes to it, the court could just issue the decision and say a dissent will be coming. But in the collegial and customary thing to do is to give someone who wants to write a dissent from denial some time, 24, 48 hours, whatever, quickly to write it. So you put that all together, and where are we? Kind of completely unpredictable, right? If you sort of do the math, it could be any time. And then if it comes to Friday, then, it's more likely that it's happening at conference. But I don't see why this motion, once it became fully ripe with the submission of Trump's brief last Thursday, I don't see why they could have really rushed it to Friday's conference. Didn't have to do that, but once they don't do that, I don't see why they would just let it stick around. So I think it's likely going in the chambers by chambers individual route, and that means we could be hearing literally anytime. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.